In a packed courtroom, my wife sobbed before the judge. We gave him everything, and he destroyed it all. My son nodded beside her. My daughter stared down at her hands. I sat still. No argument, no explanation. My attorney did not move. Then the judge stopped turning pages, set his glasses down slowly, and looked directly at me. "One moment," he said quietly. "I read about this company last week. Not in a filing, in a publication. Someone in this courtroom was lying to his face. Welcome to Dad's Revenge Stories. I'm so grateful you're here. Where are you watching from today? Drop your city or country in the comments below. Please note this story includes fictional elements added for entertainment and educational purposes. Any resemblance to actual names or places is purely coincidental, but the core message remains valuable. I used to think that when the moment finally came, I would feel something dramatic. Rage, maybe. The room smelled like old paper and floor wax. Fluorescent lights hummed overhead, with the low, indifferent sound of institutions that have witnessed too much to be surprised by anything. I arrived early the way I had always arrived to meetings that mattered. My lawyer, Helen Marsh, was already at the table, her documents arranged in 3 neat stacks. Her expression the kind of composed that only comes from 20 years of doing this work without flinching. She looked up when I sat down and said, "How are you feeling, Walter?" I told her I felt fine. She nodded once, the way people do when they believe you but know there is more underneath. The benches behind us filled slowly. I did not turn around. I had no interest in reading the room before the room had said anything worth reading. I kept my eyes forward on the raised bench where Judge Raymond Caldwell would sit, on the state seal mounted above it, on the particular stillness of a courtroom before proceedings begin, that suspended quality, like the pause before a piece of music starts, and you already know whether it will be something worth hearing. Then I heard the door open behind me. I knew their footsteps without turning around. 42 years will do that. Maggie walked in first. She always led when there was an audience. I heard the careful click of her heels, measured and deliberate, the sound of a woman who had thought about how she would enter this room. Connor followed his stride, longer, more aggressive than he probably realized. And then Brianna, quieter her steps, hesitant in a way that told me she had not fully decided even now whether she believed in what they were doing. Not one of them acknowledged me. I want to be precise about what that felt like, because it would be easy to say it didn't affect me, and that would be a lie. There is a particular kind of hurt that comes not from cruelty, but from erasure. From the moment people you built your life around look straight through you as though you are furniture, as though the decades you shared with them are a debt they have decided they no longer owe. My jaw tightened. I pressed my right hand flat against the table and held it there until the pressure steadied me. Helen did not look up from her documents. When Judge Caldwell entered the room, rose. He was a compact man in his early 60s, with silver hair trimmed close, and the careful posture of someone who understood that bearing communicates authority before words ever do. He settled into his chair with the unhurried efficiency of a man who had never felt the need to perform seriousness because he had simply always possessed it. He opened the file in front of him and began reading without announcement, without preamble, without any of the theater that smaller proceedings sometimes invited. Connor's attorney, a man named Gerald Stokes, spoke first. His voice was the kind of smooth that came from years of practice rather than conviction, practiced sympathy laid over iron calculation. He described Harmon Capital Partners as an operation under severe stress. He used phrases like pattern of mismanagement and deteriorating decision-making capacity and legitimate concern from family members who love him. He said the word love the way people say it when they mean leverage. Then Maggie spoke. She had been sitting with her hands folded in her lap, her black dress chosen with the kind of careful deliberation that people call grief, and I now recognized as theater. When she turned toward the judge, her chin trembled, and her voice came out fractured and soft-engineered to sound like it was costing her something. "We gave him everything," she said. "We stood by him for decades, and now we are watching him destroy what we all built together. We are not here to punish him. We are here because we love him, and we are terrified of what comes next if nobody steps in." Connor nodded beside her. Slow grave the portrait of a reluctant son doing a painful duty. Brianna looked down at her hands. My throat tightened. Not because Maggie's words surprised me. They did not. I had been reading the draft of this moment for 18 months, watching it assemble itself line by line from a distance. What made my throat tighten was the fluency of it, the ease with which 42 years could be translated into a performance, how completely a person could learn to cry on command and call it love. Helen remained motionless beside me. She did not object. She did not interrupt. She had told me beforehand, let them finish. Let them say everything they think they have. Then we go. Judge Caldwell listened. He turned pages. The room held itself in a careful quiet, the kind that carries weight. And then something shifted. He stopped turning pages. He removed his glasses and set them down on the bench with a deliberateness that made Gerald Stokes pause mid-sentence. The judge leaned back slightly and looked up, not at the attorneys, not at Maggie, not at Connor. He looked directly at me. His expression was unreadable in the way that only the most experienced judges manage, giving nothing away while taking everything in. "I need to ask something," he said, his voice carrying across the room without effort, "about the company at the center of this petition." He paused. "Because I believe I read about it recently. Not in a legal filing." Another pause. "In a business publication." Maggie's soft crying stopped. Connor's attorney straightened in his chair. "Someone in this courtroom," Judge Caldwell said quietly, "is not telling me the truth. And before we go any further, I intend to find out who. Before I tell you what Judge Caldwell said next, I need to take you back. Not because I want your sympathy. I have never been comfortable asking for that. I want to take you back because context is the only honest way to tell a story. And the story that played out in that courtroom did not begin with a legal filing or a forged signature. It began in 1981 in a rented office space on South Tryon Street in Charlotte, North Carolina, with a second-hand desk, one working phone line, and a business plan I had written by hand on a legal pad because I could not yet afford a secretary. I was 26 years old. I had $400 in a checking account and a clarity of purpose that I now recognize as the particular gift of people who have nothing to lose and therefore nothing to protect except the idea itself. Harmon Capital Partners did not start with investors or family money or a safety net of any kind. It started with work. 16-hour days, cold calls to men who had no reason to trust me, contracts that took 6 months to close, and the stubborn refusal to interpret a closed door as a permanent wall. By 1987, we had 12 clients and a real office. By 1995, we had a reputation. By 2005, Harmon Capital Partners was the kind of firm that other firms mentioned when they were trying to explain what they aspired to become. I tell you this not to impress you. I tell you this so that when I describe what my family attempted to do, you understand exactly what they were reaching for. Eleanor was with me for all of it. We met in 1982 at a charity dinner I almost didn't attend because I had a quarterly report due the following morning. She was a school librarian from Roanoke, Virginia, which meant she had read more books than anyone I had ever met and had strong opinions about every one of them. On our second date, she told me my tie was the wrong shade of blue for my complexion, and I found myself laughing in a way I hadn't in years. We were married 8 months later. Connor was born in 1986. Brianna came 3 years after that. Eleanor was the architecture behind the life I appeared to be living. She kept the household while I kept the company. She raised our children with more patience and more wisdom than I ever managed to bring home from the office, and she did it without complaint, without resentment, without ever making me feel that my absence was a wound she was hiding. When Connor was 12, she told me, "Walter, your son doesn't need your money. He needs your Tuesday evenings." I started protecting Tuesday evenings after that. It was one of the few pieces of advice I took quickly enough to matter. She was diagnosed in the spring of 2001. Ovarian cancer stage 3 discovered late. The way these things so often are, quietly after the window for easy intervention had already passed. She fought it for 4 years with the same composure she brought to everything else in her life. The same steady refusal to make her suffering the center of any room she was in. She died in March of 2005 in the bedroom of our farmhouse outside Roanoke, Virginia, on a Tuesday morning with Connor and Brianna and me beside her. We buried her on the property on a small rise behind the house where she used to read in the afternoons when the light came through the trees, at an angle she said was the closest thing she knew to perfect. I kept the house. I kept the land. For 18 years after her death, I drove up to Roanoke every spring, stood at her grave, and said whatever needed to be said out loud to a woman who had deserved far more of my time than I gave her while she was living. Maggie came into my life in 1998, 3 years before Eleanor's diagnosis, at a firm event in uptown Charlotte. She was charming and attentive and genuinely funny, which I had not expected. And for 2 years, we built something that felt, at least from the outside, like a second chapter written with more care than the first. We married in 2000. She had no children of her own. Connor and Brianna were teenagers, then old enough to be polite about the situation, and young enough that I believed the politeness was warmth. For a long time, I had no reason to question that belief. Maggie settled into the life I had built, with an ease that I mistook for appreciation. She involved herself in the household, in the social calendar, in the particular rituals of a Charlotte family, with standing and a recognizable name. She was present at every firm dinner, every community event, every occasion that required the version of Walter Harmon who wore the right suit and said the right things to the right people. She was good at all of it. Better than I was, honestly, at the performance of it. I was the one who built things. She was the one who understood how things looked. I told myself that was a partnership. I told myself that for 22 years. What I did not understand then, what I understand now with a clarity that costs something to carry, is that there is a difference between a person who builds a life beside you and a person who waits patiently beside a life they intend to one day claim. From the outside, those two people look identical. The difference only becomes visible when you slow down long enough for them to move. In March of 2023, I slowed down, and within 2 weeks they moved. They came with a bottle of Napa Valley Cabernet and warm smiles, and I remember thinking how coordinated they looked, the three of them standing at my front door on a Sunday evening in March. Maggie already inside because she lived there. Connor holding the wine like a prop he had rehearsed, Brianna carrying a dish. She had made herself something with roasted vegetables that she set on the counter with the careful pride of a person trying very hard to appear relaxed. I noticed all of it. I noticed it the way you notice weather changing, not with alarm, but with the quiet attention of someone who has spent 40 years reading rooms for a living. "Hadad," Connor said, pulling me into a handshake that became a half-hug. "You look good. You been sleeping okay?" "I sleep fine," I said. "Always have." He nodded and smiled and moved into the kitchen, and I stood in the doorway another moment longer than necessary, watching the three of them arrange themselves around my counter with the practiced ease of people who had discussed this evening beforehand. Dinner was good. I will give them that. Maggie had made the pot roast. I had always liked the one with the pearl onions and the red wine reduction that took most of the afternoon to get right. Connor talked about a development project he was consulting on in Raleigh. Brianna asked about my garden, whether the tomatoes were coming in the way I wanted. The conversation was warm and full and carefully steered away from anything that required me to think too hard. And I sat at the head of my own table and felt for the first time, in longer than I wanted to admit, that my family was genuinely glad to be in the same room as me. That feeling lasted until the dishes were cleared. Connor set his wine glass down and leaned forward with his elbows on the table, the posture of a man about to say something he has been building toward all evening. "Dad," he said, "we've been talking, the three of us, and we want you to know it comes from a place of love completely." He paused. "We think it might be time to consider transferring your legal authority, a durable power of attorney, just so that if anything ever came up medically or otherwise, there would be someone in place to handle things without delay." I looked at him, then I looked at Maggie, then at Brianna. "I'm 68 years old," I said. "Not 88, and I ran a $40 million firm last quarter without any assistance." "Dad, it's not about capability," Brianna said quickly, her voice softer than Connor's, shaped to sound like reassurance. "It's about planning. Everyone does it eventually. Then everyone can do it when they're ready," I said. "I'm not ready." The silence that followed was not the silence of people absorbing a reasonable answer. It was the silence of people recalibrating. I watched it move across the table like a current. Maggie reached for her wine glass, and when she set it back down, something in her face had shifted. Some small warmth had been switched off behind her eyes efficiently, the way you turn off a light in a room you are leaving. Connor leaned back in his chair. Brianna looked down at the tablecloth and began smoothing a crease with her thumb that was not there. "Well," Maggie said, her voice pleasant and entirely empty. "Who wants coffee?" The rest of the evening passed without incident. Connor talked about the Raleigh project again. Brianna mentioned a friend's wedding. Maggie kept the coffee cups filled and laughed at the right moments. But the texture of the room had changed in a way that I could feel in my sternum, that particular pressure of being in a space where the real conversation has been decided, and everyone is simply waiting for the performance to end. They left at 9:30. Connor shook my hand again at the door, firm and brief. Brianna hugged me, and I felt her arms tighten for just a moment longer than usual, something urgent in it that I did not yet know how to name. Maggie kissed my cheek and said she would be up shortly. She wanted to get some air. I went to the study and sat down. I could hear Brianna's voice from the driveway, low and quick, and Connor's underneath it, steadier. I could not make out the words. I told myself it was nothing. Adult children talk to each other. It did not have to mean anything. I picked up a book from the side table and opened it to a page I had already read, and stared at it without absorbing a single sentence. 20 minutes later, Maggie came upstairs. What I did not know, what I would not discover for another 6 months, was that Brianna had not gone straight to her car after that hug. She had stood in the hallway for 40 seconds after I walked away, long enough to open the door to my study, cross the room to my desk, and photograph the contents of 3 folders she had no reason to be looking at. Quarterly statements, a property deed, my personal signature card from the firm. She had come for dinner. She had also come for something else. And I had held the door open for her myself. Frank DeLuca called on a Tuesday morning in April, 3 weeks after the Sunday dinner, while I was sitting at my desk, reviewing a contract renewal for one of our longest-standing clients. Frank had been my business partner in the early years before he stepped back to manage his own investment portfolio, and in 45 years of friendship, I had learned to read his voice the way sailors read water. There were tides to it. That morning the tide was careful, the particular carefulness of a man who has information he wishes he did not have. Walterby, he said, I got a call yesterday from an audit firm, calling themselves Meridian Financial Review. They said they were conducting an independent assessment of Harmon Capital Partners on behalf of the Harmon family. I set my pen down. Malaito. They wanted to know about our partnership structure from the early 90s. Frank continued. Asked about the capital distribution agreements, the original founding documents, whether there were any outstanding claims between us. He paused. Walter, I've been in business long enough to know what that kind of call means. Who authorized this? Nobody authorized it, I said. Not from my end. The line was quiet for a moment. Then Frank said carefully, Connor's name came up as the point of contact. I stood up from my desk and walked to the window. Charlotte spread out below me, the late morning light cutting across the uptown skyline in long, flat angles, and I stood there looking at it while something cold and specific settled in my chest. Not shock. I want to be honest about that. What I felt was closer to confirmation, the way a doctor's report can feel less like news and more like the formal naming of something you have already been carrying for weeks. I said, thank you for telling me, don't give them anything else. Not a chance, he said. But Walter, listen to me. Whatever this is, don't wait. You understand what I'm saying, don't wait. I told him I understood. I hung up and stood at the window for another minute. And then I went to the filing cabinet behind my desk and pulled out the master folder I kept for exactly this kind of situation, the one labeled simply administrative, which contained every foundational document Harmon Capital Partners had ever produced. The original articles of incorporation, the capital structure agreements, the board minutes, going back to 1987, all of it organized with the particular precision of a man who had learned early that paperwork was not bureaucracy. It was armor. I sat back down and read through it slowly, not because I had forgotten what was in it, but because I wanted to see it the way Connor would see it, as someone looking for a seam, a gap, a number that could be reframed, or a clause that could be misrepresented. I read for 2 hours. I did not find a seam. But I understood by the end of those 2 hours that the absence of a seam would not stop someone determined enough to manufacture one. That evening I did something I had not done in years. I went through Maggie's desk. I am not proud of that. I want to say that plainly. 42 years of marriage carries its own moral weight, and going through a person's private papers is a line I had never crossed, and did not cross lightly. But Frank's call had shifted something in my understanding of what was happening in my own house. And there are moments when the instinct for self-preservation overrides the habits of trust. In the second drawer beneath a stack of household receipts and a catalog from a garden supply company, I found a yellow legal pad. 3 pages of notes in Maggie's handwriting, neat and methodical, the way she was always neat and methodical. Property addresses with estimated values beside them. Account numbers I recognized as mine with balances written next to them in round figures. The Charlotte house, the Virginia property, 3 investment accounts. The firm's approximate valuation written at the bottom of the second page with a circle around it. My name was at the top of the first page, underlined twice. I stood in the doorway of her study with that legal pad in my hands for a long time. I thought about the pot roast she had made the previous Sunday. I thought about the way she had kissed my cheek when she said goodnight. I thought about 22 years of mornings and the specific texture of a life shared with someone who has been conducting an inventory of it behind your back. Then I put the legal pad back exactly where I found it. I smoothed the catalog back over it. I closed the drawer. I called my attorney the next morning. I told her I needed a personal consultation separate from any firm business and that I needed it to stay between us. She asked no questions. She said she had an opening at 2 o'clock. That afternoon, I sat across from Helen in her office on East Trade Street and told her everything: the Sunday dinner, Connor's proposal, Frank's phone call, and the legal pad in Maggie's desk drawer. Helen listened without interrupting. When I finished, she folded her hands on the desk and looked at me with the steady directness that had always been her most useful quality. "Walter," she said, "I want you to go home tonight and act like nothing has changed. Can you do that?" "I've been doing it for months," I said. She nodded slowly. "Then keep doing it. And starting tomorrow, we document everything." She brought homemade cookies, snickerdoodles, which had been my favorite since the children were small, and which Brianna knew perfectly well, because she had made them every Christmas for 20 years. She arrived on a Saturday afternoon in August, unannounced, but not unexpected the way adult children sometimes show up when they are carrying something they have not yet decided how to say. She had a tote bag over one shoulder and a smile that worked hard to reach her eyes, and when I opened the door, she stepped forward and hugged me with both arms, firm and deliberate, the hug of someone who needs the physical contact to remind herself that what she is doing is justified. I was in the neighborhood," she said. "You live 40 minutes away," I said. She laughed a little too quickly. "I had an errand. Figured I'd stop by." I let her in. That is the part I returned to in the quieter moments since. I let her in. I took the cookies from her hands and said they smelled wonderful, and asked if she wanted tea, and she said yes, please, and I went to the kitchen to put the kettle on, while she settled herself in the living room with the particular ease of someone who has been in a house so many times that her body remembers where everything is. My phone rang while the water was heating. It was Lena Marsh, my assistant of 15 years, calling about a contract amendment that needed my attention before Monday. Lena had joined Harmon Capital in 2008 straight out of University of North Carolina at Chapel Hill, and in 15 years she had become the most indispensable person in my professional life. The kind of assistant who anticipates what you need before you have finished forming the thought. She had a question about a clause in the amendment, something that required me to pull up the original agreement on my desktop, which meant going to the study. "Give me 2 minutes," I told her. I set the kettle to finish on its own and walked down the hallway to the study. The door was half open the way I always left it. I sat at the desk, found the file, answered Lena's question, and spent perhaps 8 minutes on the call in total. When I came back to the kitchen, the kettle had clicked off, and Brianna was standing at the counter, already pouring the water into the mugs she had found in the cabinet above the sink. "Didn't want it to go cold," she said, and handed me a mug and smiled. We sat together for an hour. She talked about her work, a landscape architecture project in Wilmington that she was genuinely excited about. And I was glad to hear the real enthusiasm in her voice, because Brianna had always been the one who cared about growing things, about the shape of outdoor spaces, about what a yard said about the people who kept it. That part of the visit was real. I believe that. Underneath everything that came later, my daughter sat at my kitchen table and talked about her work with honest pleasure. And I sat across from her and thought about how strange it was to love someone and not fully trust them at the same time. She left at 4:30. Another long hug at the door. I watched her car back out of the driveway and stood on the porch until it disappeared around the corner. It was Lena who first noticed something was wrong. The following Wednesday, she called me about a document request from our compliance department, a routine matter, except that the request referenced a signature authorization form that Lena could not locate in the master file. She had last seen it in the secure folder 3 weeks prior. It was a standard form, the kind that carried my personal seal alongside my signature, used for authorizing transactions above a specific threshold. Not the kind of document that moved on its own. Did you take it home? She asked. Or authorize anyone to access the folder? No, I said. There was a pause. Walter, the seal impression record shows the folder was accessed on a Saturday. 6 weeks ago. I did not say anything for a moment. I sat with the phone against my ear and thought about a Saturday in August. About a kettle set to finish on its own. About 8 minutes on a call in the study while my daughter poured hot water in the kitchen. About the particular ease of someone whose body remembers where everything is in a house she has visited her entire life, including the location of the cabinet above the sink and the combination to the safe behind the painting in the hallway, which I had shown her years ago in case of emergency. Ooh, pull everything, I told Lena. Every original document. Move it to the secondary location we discussed with Helen. Do it today. Already started, Lena said quietly. That was the thing about Lena Marsh. She anticipated what you needed before you finished forming the thought. That evening, I sat in the study for a long time without turning the lights on. The cookies were still on the counter in their container, half a dozen snickerdoodles wrapped in wax paper, with a small ribbon tied around it, the way Brianna had done since she was 12 years old. I did not throw them away. I put them in the refrigerator and closed the door, and stood in the kitchen in the dark, and thought about what it meant to raise a child, to hand her every tool she would ever need, and to watch her use those tools to dismantle the life that had given them to her. I did not cry, but I came close. And for me, that is saying something. Frank called on a Monday morning in October, and I knew before I answered that something had shifted. Frank DeLuca did not call on Monday mornings. He was a Wednesday afternoon man, the kind of person who let the week settle before he engaged with it, who believed that anything worth discussing was worth waiting until the dust of the weekend had fully cleared. A Monday call from Frank meant something had reached him over the weekend that he could not hold until Wednesday. Walter, he said, and then he stopped, which was unusual because Frank was not a man who stopped. I got an invitation on Saturday, from Brianna. I set my coffee mug down on the kitchen counter. What kind of invitation? A cocktail party, he said. Thursday evening, the Dunhill Hotel uptown. It says, I heard paper moving on his end, the sound of him reading carefully. It says, and I am reading this word for word. Walter, it says an evening to honor Walter Harmon on the occasion of his retirement from Harmon Capital Partners, due to health considerations. With gratitude for 40 years of leadership and friendship. I stood very still in my kitchen. Walter. Frank said, I'm going to ask you something directly, and I need you to answer me the same way. Did you retire? I was at my desk at 8 o'clock this morning, I said, a long breath on his end. That's what I thought. I've already gotten 3 calls from people who received the same invitation. Tom Weatherly called me Sunday night. He said he'd already sent a gift, a crystal decanter monogrammed. He felt terrible when I told him to hold off. Tom Weatherly had been a client of Harmon Capital for 26 years. He had trusted me with his family's finances through 2 recessions and 1 divorce, and now he was monogramming crystal for a retirement I had never announced to a gathering I had not known existed, organized by a daughter who had brought me snickerdoodles 8 weeks earlier and held the door open with both hands while she walked out with my seal. Who else got invitations? I asked. Frank read me the list. 11 names. Every major client relationship Harmon Capital had built over 4 decades. Board members, industry contacts, men and women who had referred business to us, who had trusted us with portfolios that represented their children's futures and their own. The guest list was not random. It was surgical. Brianna, or whoever had helped her compile it, had selected the exact people whose perception of Walter Harmon mattered most to the ongoing operation of his company. "I need you to call Tom Weatherly back," I said. "Tell him the event is not authorized. Don't explain more than that. Just tell him you've spoken with me directly and I am not retiring." "Already drafted the message," Frank said. "Waiting on your word." "Send it." I hung up and stood at the kitchen window for a long moment, looking out at the backyard where the October light was coming through the oak trees. In the long, slanted way it did in the fall, the same light I had looked at every October morning for 19 years in this house, and I felt something that I can only describe as a kind of geometric clarity, the way a picture that has been slightly out of focus suddenly sharpens, and you realize the blur was never in the image but in the way you were choosing to see it. This was not impulsive. That was the thing I needed to understand and hold on to. A cocktail party at the Dunhill Hotel with a curated guest list of 11 people who represented the professional backbone of my company, organized with enough lead time to send printed invitations and arrange a venue, was not the action of someone acting out of frustration or fear. It was the action of someone executing a plan that had been designed over months, stress-tested, approved. Someone had decided that the most efficient way to make Walter Harmon irrelevant was not to fight him directly, but to simply announce his absence to everyone who mattered and let the assumption do the rest. I called 3 more people from the guest list myself. Each conversation had the same texture, the careful politeness of people who had heard something that troubled them and were relieved to hear my voice on the other end. Margaret Holloway, who had invested with us since 1998, told me she had almost sent flowers. Jim Reardon from the Reardon Family Trust said he had drafted an email to his son about transitioning the account. I told them both the same thing. I was not retiring. I was not ill. I would be in touch. When I hung up after the 3rd call, I went to my study and opened the top drawer of my desk. I took out a small digital recorder, the kind I had used for decades to document meetings and phone calls, a habit I had developed in the early years of the business, when a handshake agreement had cost me a contract I could not afford to lose. I set it on the desk in front of me and looked at it for a moment. Then I picked up my phone and called Lena. "I need you to check something," I told her. "The building security system at the house, the one we upgraded last spring. Does it log audio internally or just motion?" There was a brief pause while she checked. "Both," she said. "Audio and motion, stored on the private server. 30-day rolling archive, but you can flag specific dates for permanent retention." "Flag everything from March 1st forward," I said. "Every date, permanent retention." "Done," Lena said. "Walter, are you all right?" "I'm fine," I said. "I'm better than fine. I'm paying attention. I found the statements on a Thursday afternoon in November, 3 weeks after the party that was never mine to attend. I had asked Lena to pull a full reconciliation of the corporate card accounts going back 18 months, framed as a routine audit review, the kind of thing I requested periodically, and which would not on its surface signal anything unusual to anyone who might be watching the firm's internal processes. Lena brought the printouts to my office in a manila folder without comment, set them on the corner of my desk, and left without being asked to. That was Lena. She understood the geometry of certain silences. I started at the beginning. January of the prior year, working forward through each month in sequence, the way I had always reviewed financial documents systematically without skipping ahead, because the habit of patience had saved me more than once from missing something that only revealed itself in the accumulation of smaller details rather than in a single obvious entry. By the time I reached April, I had found 11 transactions that required a second look. By June, the number was 23. By the time I reached the end of the stack, I had a separate sheet of paper beside me with 47 line items circled in red, totaling $280,000 in charges that had no corresponding business purpose, no client code, no project designation, nothing that connected them to the operation of Harmon Capital Partners in any legitimate way. Tiffany and Company on Phillips Place, $4,600. A spa resort in Scottsdale, Arizona, 11 nights, $12,200. A jewelry repair and appraisal service in Myers Park, $840. A contractor in South End, Charlotte, not a commercial contractor, a residential one specializing in kitchen renovation and custom cabinetry. $31,000 across 7 separate invoices. I did not recognize the address on the contractor invoices. It was not our home address. It was not any property I owned or had authorized work on. I wrote the address down on a separate piece of paper and set it aside. Lena knocked and came in 20 minutes later to collect the folder. She saw the red circles on my sheet and the separate piece of paper with the address and did not say anything for a moment. Then she said, "Do you want me to cross-reference the contractor invoices against the property records?" "Yes," I said. "And pull her travel records. Any trip charged to the card in the last 18 months, I want dates, destinations, duration." Lena nodded and took the folder back. At the door, she paused. "Walter," she said without turning around. The card was in her name. As an authorized user, that's going to matter. "I know," I said. "Pull it anyway." What Lena brought back the following morning told me what I needed to know, which was less about the money and more about the architecture of deception, about how long a person can sustain a parallel life inside the infrastructure of a shared one. The address on the contractor invoices belonged to a condominium in the South End neighborhood, a 2-bedroom unit with a parking space and a rooftop terrace purchased 14 months earlier in Maggie's maiden name, Margaret Louise Calloway, a name I had not heard used in 22 years of marriage, $31,000 in renovations, on a property I did not know existed, paid for with a card issued under the business I had built before she entered my life. I sat with that information for a long time before I called Helen. When I did, I read her the figures without editorial. Helen listened without interrupting the way she always did, and when I finished, she asked 2 questions. The first was whether Maggie had written authorization for personal use of the card. I told her she had a general authorization as a household account holder, standard language that covered reasonable domestic expenses. Nothing that could be reasonably interpreted to cover 11 nights at a Scottsdale resort, or the renovation of a condominium registered in her maiden name. And the second question, I asked. "Did you know about the condo?" Helen said. "No," I said. A pause. "Walter, I need you to understand something. This is not just a marital issue. If these funds were drawn from a corporate account without proper authorization and used for personal enrichment unrelated to the business, that is misappropriation. That is a legal matter separate from anything happening in your marriage." "I understand," I said. "Good," Helen said, "because they are going to use that card against you. They are going to argue that you authorized these charges, that your management of the firm's finances was so loose and so compromised that even your own wife could drain $250,000 without your knowledge. They are going to make your ignorance look like incompetence." I thought about that for a moment, about the particular cruelty of being made to look careless for trusting someone, about the 42 years of mornings I had shared with a woman who had been building a separate life piece by piece, renovation by renovation, in a neighborhood I drove through twice a week, without ever knowing she had a key to a door there. That evening, I came home to find Maggie in the kitchen making dinner. She had music on something soft and instrumental, and she was moving around the kitchen with the comfortable ease of a woman entirely at home in her own life. She looked up when I walked in and smiled and asked how my day was, and I told her it was fine. I set my briefcase by the door. I loosened my tie. I sat down at the kitchen island and watched her cook and thought about $31,000 worth of custom cabinetry in a place she went when she was not here. "Smells good," I said. "Pot roast," she said. "Your favorite." "It is," I said, and I smiled back. Eleanor is buried on a small rise behind the farmhouse outside Roanoke, Virginia. Beneath a white oak tree she planted herself the spring we bought the property. She had carried the sapling in the back seat of our station wagon from a nursery in Blacksburg wrapped in burlap, and set upright against the door with the careful attention she gave to living things. And she had planted it herself that same afternoon, tamping the soil down around the roots with her bare hands, while I stood on the porch with 2 glasses of iced tea and watched her work. That tree is 40 years old now. Its canopy spreads wider than the porch roof. Every spring when I drove up to Roanoke, I would stand beneath it and feel something I could not adequately name, a kind of quiet that did not exist anywhere else in my life. I made the drive in April the way I did every year without exception. Route 77 north through Statesville across the state line into Virginia, the landscape opening up into the long green rolls of the Appalachian foothills that always reminded me of the early years of weekend drives Eleanor and I used to take before the children came, before the company demanded the kind of attention that left no room for aimless afternoons. I had the windows down. It was a warm April, the dogwoods already past their peak, the roadsides lined with the particular green of a Virginia spring that has no equivalent anywhere I have ever traveled. I turned onto the county road that led to the property, and I saw the sign from 200 yards away. It was a construction notice, orange and white, mounted on a metal stake at the entrance to the gravel drive. I pulled over and got out of this car. The sign indicated a development survey in progress authorized by the new property owner pending county approval for subdivision. There was a case number and a contractor name and a date of authorization in January of the current year. I stood on the gravel shoulder and read it 3 times. Then I called the Roanoke County Assessor's office from the driveway. The woman who answered was polite and efficient, and told me in the same tone she would use to describe any other transaction that the property at that address had been transferred in January, recorded with the county on the 14th, and that the deed of transfer listed the seller as Walter James Harmon of Charlotte, North Carolina. My full legal name, on a document I had never signed. I thanked her and ended the call. I stood on the shoulder of that county road for a long time. The April wind moved through the trees along the fence line with a sound like paper, and somewhere down the road, a tractor was working a field, and the white oak was visible from where I stood, just the top of it, above the roofline of the farmhouse, that wide canopy Eleanor had grown from a sapling with her bare hands, now standing on land that a notary I had never met had certified belonged to someone else. I am not a man who cries easily. I want to say that without apology and without pride, simply as a statement of fact about how I am built. I had not cried at Eleanor's funeral. I had stood at the graveside in March of 2005 and felt the grief move through me like weather, enormous and real and entirely interior. And I had not cried because Eleanor would have found public weeping impractical, and because I had 2 children beside me who needed to see that loss did not require collapse. But standing on that gravel shoulder in April, looking at an orange construction notice nailed to the gate of the only place on earth where I still felt close to her, I felt something come loose in my chest that I did not have the architecture to contain. My eyes burned. My throat closed. I pressed one hand against the roof of my car and stood there for several minutes with my jaw tight and my chest full of something I had no name for, that was larger than anger and older than grief. I did not go through the gate. There was nothing on the other side of it that belonged to me anymore. Not legally, not according to the county records of Roanoke, Virginia. and I was not ready to stand beneath that oak tree knowing what I now knew about who had put their name on the deed. I got back in the car. I sat in the driver's seat for a moment with both hands on the wheel. Then I called Helen. "Shakti Connor sold the Virginia property," I said. "January 14th, forged signature, notarized by someone I've never met." Helen's response was immediate and precise. "Do you have the deed transfer information?" "Case number, contractor, recording date. The county has the full record." "Good," she said. Walter listened to me carefully. A fraudulent real estate transfer executed with a forged signature is a felony under Virginia law. The transaction can be voided. You will get the property back." "I know," I said. "Then why do you sound like that?" I looked out through the windshield at the gravel drive and the orange sign and the top of the oak tree above the roofline. "Because the law can give me back the deed," I said. "It cannot give me back the afternoon she planted that tree." Helen did not answer right away. When she spoke, her voice was quieter than usual. "No," she said. "It cannot. But we are going to make sure they answer for every single thing they took. I promise you that." I started the engine. I pulled back onto the county road and drove south toward Charlotte, and I did not look in the rearview mirror because I already knew what was behind me, and I needed to keep my eyes on what was ahead. I need to take you back 2 months before Virginia to a Tuesday morning in February, when I found something that should have come with a warning label, but arrived instead between a takeout menu from a Thai restaurant and an old Duke Energy bill tucked inside a manila folder that Brianna had left on my kitchen counter during a visit the previous week and had not called to retrieve. Brianna forgot things at my house with some regularity. Scarves, sunglasses, once an entire bag of groceries she had bought for herself, but left behind when we got to talking. I had always assumed it was absent-mindedness. Standing in my kitchen that Tuesday morning with the folder in my hands, I began to reconsider whether any of it had ever been accidental. The folder contained 3 documents. The first was a brochure, glossy and professionally designed for a facility called Pinehurst Senior Living, located in Pinehurst, North Carolina, approximately 90 miles southwest of Charlotte. The brochure described private suites, a memory care wing, a dining room with what it called chef-prepared meals, a garden courtyard, and a staff-to-resident ratio it presented as a point of pride. It was the kind of place that cost serious money and was marketed to families who needed to believe they were doing right by someone they had decided could no longer do right by themselves. The second document was a deposit confirmation. $18,000 paid by electronic transfer from an account in Connor Harmon's name to Pinehurst Senior Living, dated February 3rd of the current year. The deposit secured a private suite reservation designated as priority placement, held for 60 days pending final admission paperwork. The third document was an intake form partially completed. In the field marked resident name, someone had typed Walter James Harmon. In the field marked date of birth, they had my birthday correct to the day. In the field marked emergency contact, Connor Harmon's name and phone number were listed first. Maggie's second, Brianna's third. My name was not listed under emergency contact. I was listed under resident. I sat down at the kitchen table because my legs decided they were done standing. Not from weakness, I want to be clear about that, but from the particular physical response that comes when the mind receives information so contrary to its understanding of reality that the body requires a moment to catch up. I was 68 years old. I had run a $47 million firm through the previous fiscal year without a single missed deadline or a single board member raising a concern about my capacity. I had driven myself to Roanoke and back the previous month without stopping. I read 3 newspapers every morning before 7 o'clock and could recall the contents of any financial document I had reviewed in the past decade with a precision that routinely surprised people half my age. And my son had put a deposit on a room for me, without asking, without a conversation, without a single word exchanged between us that acknowledged I was a person capable of participating in a decision about my own life. He had transferred $18,000 and typed my name into a form and selected a suite and circled a move-in window and done all of it with the administrative efficiency of someone checking a task off a list. I thought about the first time Connor had asked me for career advice. He was 24, fresh out of Duke with an MBA, and the particular confidence of a young man who has been told he is exceptional often enough to believe it entirely. He had sat across from me at this same kitchen table and asked me how I had known at the beginning that Harmon Capital was going to work. I had told him the truth, which was that I had not known. That certainty was a story people told after the fact, and that what had actually carried me through the early years was not confidence but discipline, the daily decision to show up and do the work regardless of whether the outcome was visible yet. He had nodded and thanked me, and gone on to build a consulting career that was competent and comfortable and entirely without the discipline I had described. I put the folder on the table. I smoothed the intake form flat with my palm. I read my name in that resident field one more time, and then I took out my phone and called Frank. "Frank," I said when he answered, "I need to ask you something, and I need you to be honest with me regardless of what you think I want to hear." "When have I ever told you what you wanted to hear?" Frank said. "Do I seem diminished to you?" I said. "Cognitively, professionally, in any way that would justify what I am looking at right now?" A pause. Frank DeLuca had known me for 45 years and was constitutionally incapable of dishonesty when a direct question was put to him. "Walter," he said, "you are the sharpest person I have spoken to this week, and I had lunch with a federal judge on Monday. What are you looking at?" I told him about the folder, about the deposit, about the intake form with my name in the resident field. I heard Frank exhale slowly on his end, the breath of a man processing something that genuinely surprised him, which was not a common occurrence for Frank DeLuca. "Walter," he said, "I need you to hear me clearly. Whatever they have planned, whatever timeline they are working on, you need to be ready to move before they do. Not after. Before." "I know," I said. Do you have everything you need?" I looked at the intake form on my kitchen table, at my name typed into a field designed for people who could no longer advocate for themselves. "Not yet," I said, "but I will." I put the folder in my briefcase. I took it with me when I left the house that morning. I did not leave it for Brianna to collect. It arrived on a Wednesday in late April, which I mention only because Wednesday had always been my most productive day, the day I scheduled my most important calls and my most demanding reviews, the day I was most fully myself in a professional sense. And there was something almost deliberate about the timing, as though whoever had chosen the delivery date understood that the best way to destabilize a man was to reach him at the moment he felt most grounded. The envelope was thick and cream-colored, with a return address from a law firm I did not recognize on Carmel Road in South Charlotte. My full legal name was printed on the front with the kind of clean precision that comes from a laser printer, and a mail merged the impersonal efficiency of official correspondence that has been prepared in volume. I stood in my front hallway with my keys still in my hand, still in my coat, and looked at it for a long moment before I set my keys on the table and opened it. I read the first page twice before I allowed the meaning to fully land. It was a petition for guardianship and conservatorship filed in Mecklenburg County Superior Court under North Carolina General Statute, Chapter 35, A, which governs the legal process by which a court can appoint a guardian to manage the personal and financial affairs of an adult deemed incompetent to do so themselves. The petition alleged that I demonstrated a pattern of financial mismanagement, deteriorating cognitive function and behavior consistent with early-stage dementia. It requested an immediate freeze on my personal assets, pending a full court evaluation, and it sought the appointment of a legal guardian to oversee both my personal welfare and the management of Harmon Capital Partners. The petitioners were listed on the second page: Connor James Harmon, my son; Brianna Ann Harmon, my daughter. I set the papers down on the hallway table. I took off my coat and hung it on the rack by the door the way I did every evening, because the habits of 40 years do not dissolve in the presence of a legal filing, and because I needed 30 seconds of ordinary motion to steady myself before I read further. Then I picked the papers back up and read every page, all 23 of them. Standing in my hallway in my shirt sleeves, reading each paragraph with the same systematic attention, I brought to every document that crossed my desk, noting the language, the structure, the specific claims, and the specific omissions, the architecture of a case that had been constructed carefully over time by people who knew exactly what they were building toward. The medical evaluation was on page 11. A Dr. Raymond Fletcher, whose office address was listed in Ballantyne, had assessed me on March 14th and concluded that I exhibited early indicators of cognitive decline consistent with mild neurocognitive disorder, with recommendations for further evaluation and supervised financial management. I had never met Dr. Raymond Fletcher. I had never been to his office in Ballantyne. On March 14th, I had been in a board meeting at Harmon Capital from 8 in the morning until past 3 in the afternoon, a meeting that Lena had documented in full and that 7 other people had attended. The financial claims began on page 15. According to the petition, I had unilaterally withdrawn $5.2 million from a subsidiary account of Harmon Capital Partners and directed those funds into a series of high-risk speculative investments that had resulted in a total loss. Supporting documentation was attached in Exhibit C, including transfer authorizations bearing my signature. I turned to Exhibit C. I looked at my signature on those documents for a long time. It was close. Whoever had practiced it had spent real time on the angle of the H and the particular way I crossed the lowercase t in Harmon details that a casual observer would not question. But I had been signing my name for 68 years, and I knew the precise weight of it the way a musician knows the sound of their own instrument, and what was on those pages was a performance technically accomplished and entirely wrong in the way that only the original can feel. I called Helen at 4:17 in the afternoon. She answered on the second ring. "I have a conservatorship petition," I said. 23 pages, filed in Mecklenburg County. Margaret, Connor, and Brianna are all listed as petitioners. A pause. Not long. Helen did not indulge long pauses. "When did it arrive?" "An hour ago." "Have you read all of it?" "Twice." "Good," she said. "Don't respond to anything. Don't call any of them. Don't acknowledge receipt to anyone outside this conversation. Bring me everything tomorrow morning, 8 o'clock. Another pause. "Walter, how are you holding up?" I looked down the hallway toward the kitchen, where I could hear Maggie moving around the sound of cabinet doors opening and closing, the particular domestic rhythm of a woman preparing dinner in a house she had already decided how to divide. "I'm holding up fine," I said. "I've been expecting this." "I know you have," Helen said. "That's why we're going to be ready." I put the petition back in its envelope. I set it in my briefcase with the Pinehurst folder and the legal pad I had found in Maggie's desk 6 months earlier. 3 pieces of a picture that was now complete enough to see clearly. That evening, Maggie made chicken piccata. She had opened a bottle of Chardonnay and set 2 glasses on the table, and she talked about a neighbor's renovation project, and a book she was reading, and a trip she thought we might take in the fall somewhere warm. Maybe Savannah or Charleston, somewhere with good restaurants and easy walking. She talked the way she always talked at dinner, fluid and pleasant and entirely at ease, and I listened and responded and refilled her glass when it was low. And at no point during the meal did either of us mention the envelope that was sitting in my briefcase 6 feet from the table where we ate. My son sent me a handwritten letter in July. Not an email, not a text message, not a voicemail left at an hour designed to avoid a conversation. A handwritten letter on cream stationery embossed with the Harmon family crest that I had commissioned in 1995 as a gesture toward the kind of legacy I had believed at the time was worth commemorating. Connor had taken a supply of that stationery from the house years ago. I had thought nothing of it then. Standing in my front hallway with the envelope in my hand, I understood that he had been waiting for a use that felt proportionate to the weight of the paper. The letter was 7 sentences long. I'm going to reproduce it here as precisely as I can because I have read it enough times that it lives in me now the way certain things do when you have turned them over long enough to know every surface. He wrote, "You have had your time. The company, the reputation, the room at the head of every table. You have had all of it longer than most men get to hold anything that valuable. But holding on past the point where holding makes sense does not make you strong. It makes you an embarrassment. Sign the papers while you still have the dignity to do it quietly. No one needs you anymore, Dad. Not the firm. Not us. Not anyone." I read it standing in the hallway. Then I carried it to the kitchen table and read it again, sitting down with both hands flat on the table on either side of it, the way I used to sit when I was working through a problem that required my full and undivided attention. I read it a third time. Then I folded it along its original creases and set it on the table in front of me. My chest was tight in a way that had nothing to do with fear and everything to do with the particular weight of a specific kind of loss. The loss that comes not from what a person has taken from you, but from what you finally understand they never had to give. I had spent 38 years believing that Connor's ambition was something I had modeled for him, that the drive I saw in him was the inheritance of a father who had shown his son what it looked like to build something from the ground up. Reading those 7 sentences, I understood that what I had actually passed on was an appetite without the discipline that gives appetite its shape, hunger, without the patience that turns hunger into something constructive. He was not wrong that I had held a room at the head of every table. He was entirely wrong about what that had cost. I thought about the Tuesday evenings I had protected after Eleanor told me our son needed my time more than my money. I thought about the Little League games I had driven to in work clothes because there was no time to go home and change first. I thought about the graduation at Duke, where I had sat in the bleachers in August heat and felt something so close to pure pride that it had embarrassed me with its intensity. I had been present for this boy in every way I knew how to be present, and he had taken that presence and distilled it down to 7 sentences on embossed stationery and the word embarrassment. I did not call him. I did not call Maggie. I did not compose a response of any kind. What I did was stand up from the kitchen table, walk to my study, open the bottom drawer of my desk, and take out a clear plastic document sleeve of the kind I used to preserve important correspondence. I slid the letter into the sleeve. I labeled it in my own handwriting with the date and the sender. Then I placed it in the accordion folder at the back of the drawer behind the Pinehurst deposit confirmation and the photograph I had taken of Maggie's legal pad the night I had found it in her desk, which I had printed and dated the following morning before returning the original to where I had found it. I was building something. It was slower than what they were building, and it was quieter, and it would hold in ways that theirs would not. That evening, I called Frank. He answered on the first ring the way he always did when he knew things were moving towards something. "Connor sent me a letter," I said. "By hand. On the family stationery." A pause. "What did it say?" "That no one needs me anymore. That I should sign the papers while I still have the dignity to do it quietly." Frank was silent for a moment, and in that silence, I could hear him deciding how to respond, choosing between anger on my behalf and the more useful thing, which was forward motion. Frank DeLuca had always been better at forward motion than most people I knew. "Walter," he said, "I want you to tell me something honestly. Are you ready for what comes next?" I looked at the accordion folder in my desk drawer at the photograph, and the deposit confirmation, and the document sleeve with the letter inside it, at 40 years of careful documentation, stacked against 7 sentences of cruelty on embossed paper. "I have been ready for longer than they know," I said. "Good," Frank said. "Because I got a call this afternoon from a woman named Helen Marsh. She asked me to be available for a court date in October. I told her there was nowhere else I would be." I closed the desk drawer. I leaned back in my chair. For the first time in months, something in me that had been held very tightly began slowly and carefully to release its grip. "Thank you, Frank," I said, "for all of it." 45 years, he said simply. "That's what it means. I want to take you back to May and June, to the weeks immediately after the petition arrived. Because what happened during those 2 months is the part of this story that I find most difficult to describe without sounding like a man complaining about the mechanics of his own defeat. I am not complaining. I am explaining. There is a difference, and it matters to me that you understand it before we get to the courtroom. After Helen advised me to document everything and say nothing, I spent the first 2 weeks of May doing something I had never done in 40 years of business. I made calls without a purpose attached to them. Not to negotiate, not to close, not to follow up on anything with a deadline. I called people I had known for decades, men and women whose professional lives had intersected with mine long enough that the relationship had moved past business into something that resembled friendship, or at least the version of friendship that exists between people who have trusted each other with consequential decisions over a long period of time. I called 8 people in the first week. I framed the calls as check-ins, nothing more. "How are things? How is the family? Have you seen the first quarter numbers?" The kind of conversation that exists in every professional relationship as a way of maintaining the connection between the moments when the connection is actually needed. 6 of those 8 people already knew I was sick. Not sick in the way the petition described. Sick in the softer, vaguer way that information travels when it has been carefully released into a network by people who understand how networks work. Tom Weatherly, who had been a client for 26 years, told me that he had heard I was dealing with some health challenges and that he hoped I was taking it easy. Margaret Holloway said she had been meaning to call, but had not wanted to intrude during what she understood was a difficult period. A board member named Davis Pruitt, who had served on our advisory committee for 11 years, said with the careful diplomacy of a man who did not want to cause offense that he had spoken with Connor recently, and understood there were some family concerns about the direction of the firm. I asked Davis Pruitt directly when he had spoken with Connor. "January," he said. Connor had called him in January. I had received the petition in April. Connor had been making calls in January, which meant the campaign to reshape how people understood Walter Harmon had been running for at least 3 months before the legal filing arrived, possibly longer, long enough to reach 8 out of 8 of my closest professional contacts, and leave a residue of doubt in 6 of them that a single phone call from me was not going to fully dissolve. I called Frank after the 8th conversation and told him what I had found. "How bad is it?" Frank asked. "Manageable," I said. But it required time. They spent time on this, Frank. Real time. This was not something Connor put together in an afternoon. Somebody sat down and made a list and worked through it systematically. Maggie, Frank said. Not a question. That would be my assessment, I said. Frank exhaled. Walter, I need to tell you something I probably should have told you sooner. Connor came to see me in December, in person at my house. He brought a bottle of scotch and sat in my living room for 2 hours, telling me that you had become erratic, that the firm was suffering, that the family was frightened. He was very calm about it, very detailed. He had specific examples, specific dates, specific numbers. I felt something shift in my chest. Not surprise. Something colder than surprise. What did you tell him? I told him I had known you for 45 years, and that specific dates and specific numbers were exactly the kind of thing you had always been better at than anyone else in any room. And then I asked him to leave. Frank paused. He did not look surprised when I said it. He looked like a man checking something off a list. I sat with that image for a moment. Connor in Frank's living room, with a bottle of scotch, working through a list of names, checking off the ones who had been persuaded and moving on from the ones who had not. It was efficient. It was methodical. It was in a way I found genuinely difficult to hold on to, impressive in the cold, mechanical way that a well-designed trap is impressive before you understand that you are the thing it was built to catch. Lena called me that same afternoon with a separate piece of the picture. 3 of our senior analysts had been approached by Connor over the previous 6 months, taken to lunch individually at Bentley's on 27th, which was the kind of restaurant that signaled seriousness without being showy and told in carefully chosen language that the firm was entering a transition period and that their long-term futures might benefit from relationships with people positioned for what came next. None of the 3 had told me. All 3 had told Lena because Lena was the person at Harmon Capital in whom people confided things they did not know how to say to me directly. Did any of them take him up on it? I asked her. No, Lena said. But one of them is nervous. I thought you should know. Which one? She told me. I noted the name and said nothing further about it. There was nothing to be gained from confronting anxiety directly. What was needed was a result, something visible and unambiguous, that would make the nervous one and the 6 who had heard I was sick understand, without any further conversation, required that they had been given incomplete information by people with a specific interest in their conclusions. That result was 4 months away. I intended to make it worth waiting for. There is a particular assumption that people make about men of my generation, men who built their careers before the internet existed as a commercial force, before data moved through clouds instead of filing cabinets, before the word server referred to anything other than a person who brought food to a table. The assumption is that we adapted to the digital world the way immigrants adapt to a new country, functionally, but imperfectly, always carrying the accent of the analog world we came from. We learned enough to get by, the assumption goes, but not enough to be dangerous. Connor and Maggie had made that assumption. It was the most expensive mistake of their lives. In 1984, 3 years after I founded Harmon Capital Partners, I lost a contract worth $400,000 because a handshake agreement was remembered differently by 2 parties, and there was no documentation to settle the dispute. The other party was not dishonest. He simply remembered things the way they were convenient for him to remember, the way most people do when memory and self-interest are pulling in the same direction. I absorbed that loss, and I made a decision that same week that I would never again be in a position where my version of events could not be verified by something that existed outside my own recollection. I built a system, Not elaborate at first, just a habit of documentation, of recording, of keeping copies in places that were separate from the places where the originals lived. Over 40 years, that habit evolved as the technology evolved from paper files in off-site storage to digital archives on encrypted drives, to eventually a private server housed in a climate-controlled room in a facility on the east side of Charlotte that was registered to a holding company whose name had nothing to do with Harmon Capital Partners or with me personally. The server had been upgraded 4 times since its installation. It stored 40 years of financial records, board meeting transcripts, correspondence, transaction logs, and audio recordings of every significant meeting I had conducted since 2009, when I had installed a discrete recording function into the conference room at the firm and later into the security system at my home. Lena knew about the server. She was the only person who did. She had been maintaining it alongside me since 2011, running the weekly backup protocols, flagging recordings for permanent retention, organizing the archive with the same systematic precision she brought to everything else. When I had called her in October of the previous year and asked her to flag everything from March 1st forward for permanent retention, she had understood immediately what I was preparing for. The way she always understood the thing underneath the thing I was actually saying. On a Thursday afternoon in June, Lena and I drove together to the facility on the east side of Charlotte. She had her laptop. I had a legal pad. We signed in at the front desk and walked down a corridor that smelled of recycled air and the particular neutrality of a place designed to store things indefinitely, and we went into the small room where the server lived, humming quietly in the temperature-controlled dark, and we sat down and began to go through what we had. It took 4 hours. The financial records were the foundation. 40 years of transaction logs, every movement of capital in or out of Harmon Capital Partners, every wire transfer, every disbursement, every account reconciliation stored in a format that could be cross-referenced against the fabricated documents Connor had submitted to the court, with a precision that would not leave interpretive room for a competing narrative. There was no $5.2 million withdrawal. There had never been one. The records showed exactly where every dollar had gone for 4 decades, and none of it pointed anywhere that the petition story could survive contact with. The board meeting transcripts were the second layer. Every meeting since 2009 documented in full, including the March 14th meeting, that had been running on the same day that Dr. Raymond Fletcher had allegedly evaluated me for cognitive decline in his office in Ballantyne. The transcript showed my voice on a recording for 6 hours and 40 minutes, conducting a meeting with 7 other people present, reviewing quarterly figures with the kind of specific numerical recall that is not consistent with early-stage neurocognitive disorder in any diagnostic framework I had ever reviewed. Then Lena pulled up the Home Security Archive. North Carolina is a one-party consent state, which means that a recording made in a private residence by the owner of that residence is legally admissible as evidence in a court proceeding, provided the recording party is present or the recording is made by a system they own and operate on their own property. I owned the house. I had installed the system. Every conversation that had taken place within range of its microphones since the previous March had been captured and stored, and was sitting on a server in East Charlotte waiting to be retrieved. Lena found the file she was looking for in 40 seconds. March 19th, a Tuesday evening. The kitchen of my house on Ferncliff Road. 2 voices, both clearly audible, the acoustics of a tiled kitchen being well suited to audio capture. Maggie's voice first, confident, practical, stripped of the warmth she performed for public occasions. And then Connor's lower responsive, the voice of a man confirming a plan rather than proposing one. I will not reproduce the full conversation here. I will tell you that it lasted 11 minutes and 23 seconds, and that by the end of the 4th minute, there was nothing ambiguous about the intent behind the petition. The asset freeze request, the manufactured medical evaluation, or the destination of the assets they were planning to redirect once the incompetency ruling came through. Lena stopped the playback and looked at me across the server room. "Walter," she said, "they have no idea." I picked up my legal pad and wrote 2 words at the top of the first page. Then I called Helen. "We have everything," I said. "Schedule the court date." Helen called the medical evaluation the most cynical document she had reviewed in 20 years of practice. She said it on a Tuesday morning in July, sitting across from me in her office on East Trade Street, with the petition spread open on the desk between us. Dr. Raymond Fletcher's assessment on top, and she said it without heat, the way Helen said most things, as a precise statement of professional opinion, rather than an expression of outrage. Helen Marsh did not traffic in outrage. She trafficked in strategy, and the distinction had always been one of the things I valued most about her. Dr. Raymond Fletcher, according to his letterhead, operated a private neurology practice in the Ballantyne area of South Charlotte. His evaluation of Walter James Harmon, dated March 14th, ran to 4 pages and concluded with a diagnosis of mild neurocognitive disorder, a clinical term that sits at the entry point of a spectrum that extends toward dementia chosen. Helen explained with deliberate precision. Mild neurocognitive disorder is serious enough to support a conservatorship petition under North Carolina law, but ambiguous enough to be difficult to disprove without a competing evaluation from a qualified specialist. It was, she said, the medical equivalent of a rumor. Specific enough to damage. Vague enough to survive scrutiny longer than a harder claim would. He chose it carefully, Helen said. Whoever advised him on this knew what they were doing. Can we challenge it? I asked. We already have, she said. She slid a second folder across the desk. Dr. Patricia Owens, Neurology, Atrium Health. Board certified, 23 years in practice, no professional relationship with you or with Harmon Capital Partners, no referral connection to anyone in your network. I retained her independently 6 weeks ago. I opened the folder. Dr. Owens had evaluated me over 2 sessions in May and June, a battery of cognitive assessments that Helen listed for me without abbreviation. The Montreal Cognitive Assessment. The Mini Mental State Examination. A neuropsychological evaluation battery that ran across 3 hours on a Saturday morning and covered executive function, processing speed, verbal memory, and the kind of sustained attention that early-stage neurocognitive disorder specifically compromises. My scores were in the 93rd percentile for my age group across every category. Fletcher's evaluation has a second problem, Helen said. She turned to a page in the petition, Exhibit D. North Carolina conservatorship law under Chapter 35. Requires that a petition alleging cognitive incapacity be supported by evaluation from at least 2 independent medical professionals before the court is obligated to take it seriously at the evidentiary level. Connor submitted 1 evaluation. From a doctor with no prior relationship with you, no documented referral pathway, and a practice address that Lena checked against the state medical board registry. She paused. Dr. Raymond Fletcher was licensed in North Carolina in January of this year, 4 months before your petition was filed. His practice address in Ballantyne is a shared commercial suite that houses 11 other single practitioner operations. He has no hospital affiliations, no peer-reviewed publications, and no record of prior conservatorship evaluations in the state registry. I looked at the page she was indicating. The letterhead looked professional. The language was clinical and precise. From a distance in the hands of a judge moving quickly through a high-volume docket, it would read as legitimate. That had been the calculation. Not that it would survive scrutiny, that it would not face scrutiny because Walter Harmon would be too destabilized by the filing itself to mount the kind of response that would bring scrutiny to bear. They had miscalculated. Again. The financial claims, I said. Helen moved to Exhibit C. The $5.2 million withdrawal, documented across 4 transfer authorizations bearing my signature, each one routed through a subsidiary account of Harmon Capital Partners to an external investment vehicle registered in Delaware. The documents were dated between August and November of the prior year. The investment vehicle, according to the supporting materials Connor had included, had subsequently failed, resulting in a total loss of the transferred funds. "Show me the subsidiary account records," I said. Helen produced them. I looked at them for 60 seconds. "This account does not exist," I said. "It has a Harmon Capital account number formatted correctly, but this subsidiary was dissolved in 2018. Connor would have had access to the original account structure from his time on the advisory committee. He used a dissolved entity and reconstructed its documentation. Cha-ti-cha, that is exactly what our forensic accountant concluded," Helen said. "It took her 4 days. The account number traces to a dissolved entity. The transfer authorizations contain formatting inconsistencies with our actual wire transfer documentation from the same period, and 2 of the 4 alleged transfer dates fall on weekends when the firm's banking system does not process outgoing wires above $50,000. I sat back in my chair. The fabrication was sophisticated enough to pass a casual review. It would not pass a forensic one. Connor had built something that looked substantial from the outside and had nothing load-bearing inside it. He had been counting on the structure of the legal proceeding, the institutional weight of a filed petition, the social pressure of a family presenting a unified front to carry the case past the point where anyone looked closely enough to find the hollow center. "Patricia Owens will testify," I asked. "She will," Helen said. "She told me, and I am quoting her directly, that she would consider it a professional obligation." I thought about Dr. Fletcher's 4 pages and Dr. Owens's 93rd percentile scores, and the particular economy of a situation in which the truth was not only present, but quantified, numbered, scored, against a standardized scale available to anyone willing to look at it directly. "What do you need from me between now and October?" I asked. Helen closed the folder. "Nothing you are not already doing," she said. "Show up. Stay calm. Let the documents speak." I nodded. Outside her window, East Trade Street moved with its ordinary Tuesday momentum cars and people and the indifferent machinery of a city that did not know or care what was being decided in this room. I found that ordinary motion steadying in a way I had not expected. The world was continuing. It would continue. Whatever happened in Courtroom 7 in October would not stop it from continuing. That, I decided, was enough. The night before the hearing, I could not sleep, which was unusual for me. I had built a career on the ability to compartmentalize, to set a problem down at the end of a working day and retrieve it the following morning without having carried it through the intervening hours. Eleanor used to say I slept like a man with a clean conscience, which was her gentle way of observing that I was perhaps too comfortable leaving the unresolved things unresolved until morning. I had taken it as a compliment. I understood now that she had meant it as a question. I sat in the armchair in the corner of the study, the one that had been hers before it was mine, a wide-armed wingback in a faded green fabric that I had never reupholstered, because the fading was evidence of use, and the use had been hers. I had moved it from the bedroom to the study after she died, not as a memorial gesture, but because it was the most comfortable chair in the house, and I was practical even in grief. Sitting in it that October night, with the house quiet around me and the clock on the mantel reading 11:47, I thought about Eleanor with an intimacy that 19 years of absence had not diminished. I thought about what she would have said about the year I had just been through. Eleanor had been constitutionally incapable of indirection when something needed to be said plainly, and I believed she would have said something like this. Walter, you spent 40 years building something real. You are allowed to defend it. The fact that the people trying to take it are the people you loved does not make defending it wrong. It makes it harder. Those are two different things. I held that imagined voice in the room with me for a while. At 12:15, Frank called. I answered before the second ring, which told him everything he needed to know about how the night was going. Can't sleep either, he said, which was Frank's way of saying he had been thinking about me without making it sentimental. What are you doing up? I asked. Same thing you are, he said. Going over it. Making sure I haven't missed anything. He paused. Walter, I've been thinking about December, when Connor came to my house. I want you to know something. I should have called you that same night. I didn't because I told myself it wasn't my place to involve myself in a family matter. That was wrong. I should have called. Frank, I said. Let me finish. I should have called. I didn't. And I have thought about that every day since April when you told me about the petition. So tomorrow I am going to sit in that courtroom and I am going to watch those documents do what you and Helen have prepared them to do. And that is my version of making it right. I understand if it is not sufficient. I sat with his words for a moment. Outside, a car moved down Ferncliff Road, its headlights sweeping briefly across the study ceiling, and then gone. It is sufficient, Frank, I said. It has always been sufficient. Just be there. 7:30, he said. Coffee's on me. After I hung up, Lena sent a message. It came through at 12:41, which was late even for Lena, who kept hours that suggested she did not fully believe in the concept of evenings. The message read, Everything is loaded, indexed, and ready. 40 years on 6 drives. Helen has the copies. You have nothing left to prepare. Go to sleep, Walter. I smiled at that. I did not go to sleep, but I smiled. I opened the bottom drawer of my desk and took out the accordion folder. I went through it one final time, not because I needed to review the contents. I had reviewed them enough times that I could have recited them in sequence without the physical documents in front of me, but because there is something in the act of handling evidence of a thing that the mind requires when the thing itself is too large to hold abstractly. The Pinehurst deposit confirmation. The photograph of Maggie's legal pad, the document sleeve with Connor's letter inside it, the forensic accountant's summary, Dr. Owens's evaluation, the server access logs, 40 years of discipline distilled into an accordion folder in a desk drawer in a house on Ferncliff Road. I put the folder in my briefcase and closed it. I set the briefcase by the study door where I would not forget it in the morning, which was an unnecessary precaution, because I would not have forgotten it under any circumstances. But the habit of preparation does not distinguish between what is necessary and what is merely thorough. I went back to Eleanor's chair and sat down again. I thought about the 7 sentences Connor had written on the family stationery, about the intake form with my name in the resident field, about the construction notice on the gate in Virginia and the top of the white oak visible above the roofline, and the afternoon I had stood on the gravel shoulder and felt something come loose in my chest that I had not had the architecture to contain. I thought about Maggie's voice on the recording, confident and practical and stripped of everything she had performed for 22 years, of dinners and anniversaries, and the ordinary shared language of a long marriage. I was not angry. I want to be precise about that. What I felt sitting in Eleanor's chair at 1 in the morning on the eve of the hearing was not anger, which is a hot and consuming thing that requires fuel to sustain itself. What I felt was something quieter and more durable, the settled clarity of a man who knows exactly what happened, exactly what he has, and exactly what the morning will require of him. I took out my notebook and wrote one line on the first page. Then I closed it. The clock read 2:11. I turned off the desk lamp. I sat in the dark in Eleanor's chair and listened to the house settle around me, and somewhere in the next hour, without deciding to, I slept. Frank was waiting outside the courthouse at 7:28, 2 minutes early, with 2 cups of coffee from a place on Trade Street that he had been going to since before I knew him. He handed me mine without ceremony, the way you hand something to a person you have known long enough that the gesture requires no framing. We stood on the courthouse steps in the October morning air, which was cool and carrying the particular clarity that Charlotte mornings sometimes have in the fall, before the city fully warms up and the day becomes what it is going to be, and we drank our coffee and did not talk about what was waiting inside. "How did you sleep?" Frank asked. "Better than expected," I said. He nodded. That was enough. Helen was already at the plaintiff's table when we entered courtroom 7. Her documents arranged in the same 3 neat stacks she always brought to a hearing that mattered, her expression carrying the composed readiness of a woman who had spent the previous 3 months doing nothing but preparing for the next 2 hours. She looked up when I sat down and said quietly, "Dr. Owens is in the hallway. She'll come in when I call her." I told her that was fine. She returned to her documents. The room filled slowly. I kept my eyes forward the way I had learned to keep them in the weeks since April. The deliberate practice of a man who has decided that looking for trouble in peripheral vision is a waste of attention that could be directed somewhere more productive. I heard the door open behind me 3 separate times before the proceedings began. I did not turn around for any of them. When Judge Raymond Caldwell entered and the room rose, I rose with it and looked at him directly for the first time. He was exactly as I had registered him in the opening minutes of this story, compact, silver-haired, carrying the particular authority of a man who had presided over enough human disorder to have stopped being surprised by it without having stopped caring about it. He settled into his chair and opened the file in front of him, and the room sat back down and the hearing began. Gerald Stokes spoke first. He was Connor's attorney, a man whose voice had been manufactured in the same way that certain buildings are manufactured, designed to project confidence independent of the structural integrity of what it was supporting. He described Harmon Capital Partners as an organization in distress. He used the words erratic and concerning and deteriorating with the fluency of someone who had rehearsed them until they felt like observations rather than arguments. He told Judge Caldwell that the Harmon family had exhausted every private avenue before bringing this matter to the court, that this petition was an act of love by people who were frightened for a man they cared about deeply. My jaw tightened. I pressed my right hand flat against the table. Then Maggie spoke. She had dressed in black again, the same careful choice she had made the first time I had walked into this courtroom in my mind, preparing for it. Her voice, when she turned toward Judge Caldwell, fractured at precisely the right moment, the fracture of a woman who has practiced grief until it performs on command. She said that she had spent 42 years beside me. She said she had watched me build something extraordinary and had stood by me through every difficulty and every loss. She said that what she was doing today was the hardest thing she had ever done, and that she was doing it because she loved me, and because love sometimes required a courage that looked from the outside like something else entirely. She was crying by the end of the second sentence. The tears were real. I had no doubt about that. What they were expressing, I had somewhat more doubt about. Connor nodded beside her grave and measured. Brianna sat with her hands folded in her lap and her eyes directed at a point approximately 2 feet in front of her on the courtroom floor. The posture of a person who is committed to a position they are no longer fully certain they believe in. Judge Caldwell listened. He turned pages. The room held itself in the particular suspension of a space where something is being decided, and I sat at the plaintiff's table with my hand flat on the surface and my breathing steady and my eyes on the raised bench. And I waited the way I had learned to wait without rushing what the moment required. Then Judge Caldwell stopped turning pages. He set his pen down. He removed his glasses with the deliberate care of a man who has something to say and wants the room's full attention before he says it. He looked up, and the direction of his gaze moved past Gerald Stokes and past Helen and past the space where Maggie was still composing herself. And it settled with the precision of a man who has reviewed enough material to know exactly where his questions belong on me. Before we proceed, he said, his voice carrying across the room without effort, I want to address something that is not in these documents. He paused. I was reading a financial publication last week, a profile of a capital management firm based in Charlotte that has posted 7 consecutive years of growth and recently crossed a revenue threshold that warranted national coverage. Another pause. The firm was called Harmon Capital Partners. Gerald Stokes shifted in his seat. Mr. Stokes, Judge Caldwell said without looking at him, your petition describes this company as an organization being actively damaged by its founder's mismanagement. I have a report in front of me independently audited, showing $18.3 million in revenue for the current fiscal year. He set the report down on the bench with a precision that made the room feel smaller. I would like someone to explain that discrepancy to me before we go any further. Maggie's crying stopped mid-breath. Connor's hand moved to his attorney's arm. Gerald Stokes leaned forward and said with the recovered confidence of a man reaching for a position he has prepared. Your Honor, the petitioners are prepared to address the company's reported figures, which we believe have been selectively presented to obscure underlying liabilities. Judge Caldwell looked at him with the patience of a man who has heard a great many things that turned out not to be true. Then let's hear it, he said. All of it. Because I am also looking at a medical evaluation from a physician licensed 4 months before this petition was filed, and I have some questions about that as well. Helen placed her hand lightly on the table beside mine. She did not look at me. She did not need to. The documents were about to speak. Before I reveal the decisive moment that exposed everything in that courtroom, leave the word justice in the comments, so I know you're still here with me. Also, please note, the upcoming part of the story contains some fictionalized dramatizations and may not be entirely factual. If you prefer not to continue, feel free to close the video now. Helen placed 3 folders on the table in front of her and did not rush. That was the thing I noticed first. The thing I had always noticed about Helen in the moments that mattered most. Other attorneys filled silence with motion, with the shuffling of papers and the clearing of throats and the performance of preparation, as though busyness were itself a form of argument. Helen used silence differently. She let it accumulate, let it fill the room from the corners inward, until every person sitting in courtroom 7 was leaning toward her without realizing they had moved. And then only then she began. Your Honor, she said, I would like to walk the court through a timeline. She opened the first folder. I had seen the contents of these folders many times over the preceding months, in Helen's office in the server room on the east side of Charlotte. Spread across my desk at Ferncliff Road, in the small hours of mornings when sleep had decided to go elsewhere. I knew what each document said. I knew the order in which Helen had arranged them and the logic that connected one to the next. But sitting at that table and watching her present them to Judge Caldwell was a different experience than knowing them in private. There is something about the public presentation of truth The moment when what you have carried alone is finally laid out in a room full of witnesses that changes the weight of it. It does not become lighter, it becomes real in a way it was not before. The forensic signature analysis had been conducted by an independent examiner retained through the North Carolina State Bureau of Investigation's approved vendor list. Helen established this in her first 3 sentences calmly and without emphasis, because the strength of a credential is diminished when it is announced like an achievement rather than stated like a fact. The analysis had covered every document submitted by the petitioners that bore my signature. The 4 transfer authorizations for the alleged $5.2 million withdrawal, the medical consent forms attached to Dr. Fletcher's evaluation, the power of attorney draft that Connor had submitted as evidence of what his attorney had called a pattern of agreement followed by irrational reversal. The conclusion was uniform across every document. The signatures were not consistent with the known exemplars of Walter James Harmon's handwriting. A collection drawn from 40 years of authenticated firm documents, notarized agreements, and board minutes that had been witnessed, dated and filed in jurisdictions that did not allow for ambiguity. The forensic examiner had identified 12 specific points of divergence: the letter form construction, the pressure distribution across the pen stroke, the precise angle at which I crossed the lowercase t in my surname, a habit so particular to my hand that Helen described it as a fingerprint of movement, something that develops over decades and becomes in the end as unique as the person who produces it. The forger had come closest on that detail. Whoever had practiced my signature had spent real time on the T in Harmon. It was not a casual imitation. It was a studied one. But studied is not the same as true, and across multiple documents produced at different times, the inconsistency accumulated into a pattern that the examiner had found impossible to explain as anything other than replication rather than origin. Gerald Stokes rose to object. His voice had the recovered confidence of a man who understands he is losing, but has not yet decided to stop spending. Judge Caldwell looked at him with the patience of a man who has heard 10,000 objections in his years on the bench and has developed an accurate sense within the first syllable of which ones are going to matter. "Sit down, Mr. Stokes," he said. "You'll have your opportunity." Stokes sat. His hands went to the edge of the table. I watched Connor from the corner of my eye. He had not moved. He was sitting with the stillness of a man who has understood that stillness is his only remaining option, that any visible reaction would be read and remembered and used. I recognized the calculation. I had used it myself at this same table that same morning, when Maggie was performing her grief and I was sitting beside my attorney, and the only available tool was the deliberate management of what my face chose not to say. Helen moved to the second folder. "The petitioners allege," she said in the same measured tone she had maintained since the moment she began, "that Mr. Harmon executed these documents between August and November of last year. I would like to direct the court's attention to the travel record for August 19th, which is the date on the first transfer authorization." She placed the document on the edge of the bench for the clerk to retrieve and carry to Judge Caldwell. She did not look at Gerald Stokes while she did it. She did not look at Connor or Maggie. She kept her attention on the bench the way you keep your attention on the only thing in the room that matters. Mr. Harmon was in London on August 19th. He delivered the keynote address at the International Capital Management Conference at the Grosvenor House Hotel in Mayfair. Here is his passport entry stamp issued at Heathrow Airport on August 17th. Here is his conference registration issued in his name and bearing his photograph. Here is his boarding pass from Charlotte Douglas International Airport dated August 17th, seat, confirmed flight number verifiable through the airline's own records. And here is a photograph taken at the podium on the morning of the 19th time, stamped and geotagged by the conference's own documentation system, showing Walter James Harmon delivering remarks to an audience of 340 people at 8:47 in the morning London time. She set each document on the bench in sequence one after the other without rushing, giving Judge Caldwell the time to look at each one before the next arrived. The room was very quiet. I could hear the fluorescent lights overhead. I had not been able to hear them before. The silence had reached the depth where ambient sound becomes audible, where the ordinary hum of a building becomes the loudest thing in a space because everything else has stopped. Maggie's hands moved in her lap. A small adjustment, nothing more, but I noticed it the way I had learned to notice everything she did in the months since April. Her composure was still intact, but something underneath it had shifted the way the foundation of a structure shifts before the structure itself shows any sign of it. The second transfer authorization is dated October 3rd. Helen continued moving without pause, giving the opposition no rhythm to interrupt, no gap in which to regroup or reframe. October 3rd was a Saturday. Harmon Capital Partners' banking system does not process outgoing wire transfers above $50,000 on weekends. That is a standing operational parameter that has been in place since 2011, documented in the firm's banking agreements with First National and verifiable through the bank's own transaction records, which have been subpoenaed and are included in the supplementary materials already entered into evidence. She set that document on the bench. The remaining two authorizations contain formatting inconsistencies with the firm's authenticated wire transfer documentation. From the same period, inconsistencies our forensic accountant has identified, dated, and explained in detail in the report the court already has. Gerald Stokes was gripping the edge of his table with both hands. Not the posture of a man preparing to object, the posture of a man holding on to something because the alternative is to let go entirely. Connor had gone very still. Helen opened the third folder. "Your Honor," she said, "I would like to present a recording." She addressed the bench directly the way she always addressed the bench, as though there were no one else in the room worth speaking to. North Carolina is a one-party consent state. The recording I am about to play was captured by a security system installed and operated by Mr. Harmon on his own property at his primary residence on Ferncliff Road in Charlotte. Mr. Harmon was present in his residence at the time of the recording. The recording is legally admissible under North Carolina's one-party consent statute, which governs audio recordings made by property owners on their own premises. The recording has been authenticated by the system's manufacturer and by an independent audio forensics technician whose credentials are included in the materials before the court. She pressed play on the device in front of her. Maggie's voice came first. I had heard it many times since June, sitting in the server room, with Lena sitting in Helen's office, sitting alone at my desk at 2 in the morning, with the lights off and the house quiet around me. I thought I had processed it. I thought the repetition had created a kind of distance between me and the content of it, the way reading a difficult word enough times strips it of its initial impact. I was wrong. Hearing it in courtroom 7 through speakers in a room where a judge was listening and 30 people had gone so silent, I could hear the lights was not the same as hearing it in private. Maggie's voice, confident and practical, and stripped of every layer of warmth she had ever performed in my presence, filled the room. She said the incompetency ruling was the cleanest path. She said once it came through the shares transferred by operation of the conservatorship agreement. She said she would take the Ferncliff property and the accounts. Connor's voice responded lower, confirmatory. The voice of a man receiving a plan he had already reviewed rather than hearing it for the first time. He asked about the timeline. Maggie said October if they moved efficiently. Connor said he would handle the board contacts. Maggie said she already had. 11 minutes and 23 seconds. Helen stopped the playback after 4 minutes and 12 seconds. The essential structure of the plan had been established in the first two. The remaining time contained details that were more damaging in accumulation than in any single statement, but the court had heard enough to understand the architecture, and Helen had always known the difference between what was sufficient and what was merely additional. Brianna made a sound, not a word, a sound. The involuntary kind that a body produces when it receives information that the mind has been holding at a careful distance and can no longer keep there. She pressed both hands flat against her thighs, hard enough that I could see the pressure in her knuckles from across the room, and she stared at the surface of the table in front of her with the expression of a person who has just understood in the most complete and irreversible way that the thing she told herself she was doing and the thing she was actually doing were never the same thing. I had watched her make choices over the previous 18 months that I believed she had not fully examined. The Saturday in August, the tote bag, the 8 minutes I spent on a phone call while the kettle finished, the photograph of my files, the folder left on my kitchen counter in February. At every point, there had been a version of Brianna who was choosing Connor's plan over her own better judgment, and I had wondered in the quieter moments since whether she had known the full extent of what she was participating in. The sound she made when the recording stopped told me the answer. She had not. She had known enough to implicate herself, and not enough to protect herself, and Maggie's voice on the recording had just made that distinction permanent. Connor turned to Gerald Stokes and said something in a voice too low to carry across the room. Stokes shook his head once, a small, decisive movement. The movement of a man who has assessed the remaining options and found them insufficient. Maggie did not move. She sat with her spine straight and her hands folded in her lap and her face arranged into an expression I had not seen before in 22 years of learning to read her. Every other expression she had ever worn in my presence I had catalogued. The warmth, the performance, the careful architecture of concern, the practiced fracture in her voice when emotion was required. This was none of those. This was the face beneath all of them, finally visible, because there was nothing left worth covering it with. It was not angry. It was not frightened. It was the face of a woman who had run every available calculation and arrived for the first time at a result she had not prepared for. Judge Caldwell set his glasses down on the bench. He looked at the documents in front of him for a long moment. The forensic analysis, the travel records, the banking parameters, the device that had just played 4 minutes and 12 seconds of a conversation recorded in the kitchen of my house on a Tuesday evening in March. He looked at all of it, and then he looked up at the room with the expression of a man who has seen enough to know exactly what he is going to do and is taking one final careful moment to be certain he is prepared to say it. "I think," he said quietly, "that we have heard enough." Judge Caldwell put his glasses back on. He did it slowly with the deliberate care of a man who understands that every movement in a courtroom carries weight and who has nothing to conceal in any of them. He looked at the documents spread before him on the bench at the forensic analysis and the travel records and the banking parameters and the device that had just played 4 minutes and 12 seconds of a conversation recorded in a kitchen on Ferncliff Road. And he looked at the people arranged below him with the expression of a man who has arrived at a conclusion and is taking one final measured breath before he delivers it. The room was the quietest it had been all morning. "This petition," he said, his voice carrying to every corner without effort, "is dismissed, with prejudice, with prejudice." 2 words that carried the full weight of what they meant. It could not be refiled. It could not be revised and resubmitted under a different framing. The matter was closed in the civil court of Mecklenburg County permanently and completely. Everything the petitioners had constructed over 18 months of coordination planning and deliberate deception had been examined by a court of law and found to be without merit, without foundation, and without the basic honesty that the judicial system required of every person who stood within its walls. Judge Caldwell was not finished. I am referring this matter to the Mecklenburg County District Attorney's Office. He continued, for review of potential criminal charges including but not limited to fraud, forgery of legal instruments, misrepresentation to the court, and fraudulent real estate transfer. The relevant documentation, including the forensic signature analysis, the travel and banking records, and the audio recordings submitted into evidence, will be transferred to that office by end of business today. He paused and looked directly at Connor. I would strongly advise all parties named in this petition to retain separate criminal counsel at their earliest opportunity. This referral is not a formality. Connor's face did not change. That was the thing I found myself studying in the seconds that followed, not the verdict which I had prepared myself for. Not the criminal referral which Helen had told me was a realistic possibility, but the absolute stillness of my son's expression as he absorbed the information that his life had just shifted in a direction from which there was no simple return. Whatever was happening inside him, he had decided that showing it was no longer a card he could afford to play. I recognized that discipline. I had modeled it for him across 38 years of watching me navigate rooms where everything depended on what your face did not reveal. I had taught him that, and now I was sitting across a courtroom watching him use it against the consequences of what he had done to me. Gerald Stokes leaned toward Connor immediately, his voice low and urgent. Connor nodded once, the small, deliberate nod of a man receiving instructions he has already anticipated. His right hand moved to the table and pressed flat against the surface, and I felt something move through me when I saw that gesture, something I did not expect. Not satisfaction, not relief. Something quieter and more complicated, the recognition of a man seeing his own habits reflected in a person he raised, understanding, for the first time, how thoroughly a child absorbs not just what you teach them, but how you taught it, in what circumstances, under what pressures, toward what ends. I had pressed my hand flat against this same table that morning. We were more alike than either of us would ever be comfortable admitting. Brianna had not moved since the recording stopped. She sat with both palms pressed against her thighs, her eyes on the table in front of her, and the expression on her face was one I had not seen on her since she was 11 years old and had broken a window in the backyard throwing a baseball and had stood in the kitchen doorway trying to decide whether to tell me or let me discover it myself. That expression had always broken my heart a little. The particular look of a person who understands they have done something wrong and is only now fully reckoning with what that means. She had chosen Connor over her own better judgment, and the recording had just played back, in her mother's confident and unambiguous voice, exactly what she had been used to accomplish. I did not feel anger toward Brianna in that moment. I want to be honest about that. What I felt was something closer to grief, the specific grief of watching a person you love understand too late that they were an instrument in someone else's plan, rather than a participant in their own. Helen placed her hand lightly on the table beside mine. She did not look at me. She did not need to. 40 years of building things had taught me that the moments which matter most are rarely the loudest ones, and this was one of those moments, quiet and final and entirely sufficient. I stood up. The hallway outside courtroom 7 was long and institutional, lit by the same indifferent fluorescent lights that hummed in every corridor of every building designed to process human difficulty at scale. I walked through the doors and stopped and stood in the corridor for a moment, with my briefcase in my hand, and the October light coming through the window at the far end in long, slanted rectangles across the linoleum floor. I breathed the recycled air. I felt the particular physical sensation of a weight that has been carried for a very long time being set down, not with ceremony, not with any dramatic release, but with the quiet, almost anticlimactic finality of something that is simply over. 18 months. That was how long I had carried it. 18 months of Sunday dinners with agendas beneath them, of phone calls I knew were being monitored, of sleeping beside a woman whose desk I had searched, of driving to Virginia and finding an orange construction notice where a gate should have been. 18 months of keeping my face arranged while my family arranged everything else around me. It was over now, and the hallway outside courtroom 7 in October was where I first understood what over actually felt like. It felt like nothing dramatic. It felt like being able to breathe at the normal depth again. Maggie came through the courtroom doors before I reached the elevator. She was not the woman who had entered that room that morning. The black dress was the same, the careful posture was the same, but the thing that had animated all of it, the performance, the practiced grief, the engineered vulnerability, was gone. What was underneath was something I had seen glimpses of over 22 years and had chosen in the way that people choose to believe in the version of someone that costs them less, not to look at directly. Her eyes were dry. Her jaw was set. Her hands, when she reached for my arm, gripped with the pressure of genuine desperation rather than staged emotion, her fingers pressing hard against my sleeve, and for just a moment I felt the full weight of 42 years in that grip, the mornings and the dinners and the anniversaries and the ordinary accumulated texture of a life shared with someone who had been, for much of it, genuinely present even while planning to be elsewhere. "Walter," she said. "Walter, please. I need you to hear me." Everything I did came from fear. Real fear. I was afraid of being left with nothing. I was afraid of what happens to women in my position when the men they built their lives around decide they are finished. I watched it happen to people I knew, and I was terrified of becoming that, and fear makes people do things they would not otherwise do. I know what I did. I am not asking you to pretend it was nothing. I am asking you, after 42 years, to consider that fear before you walk away from me completely. I looked at her hands on my arm. I looked at her face. I thought about the yellow legal pad in her desk drawer, with my name underlined twice at the top. I thought about the condominium in the South End, registered in her maiden name, Margaret Louise Calloway, a name I had not heard in 2 decades, renovated with $31,000 charged to the company I had built before she entered my life. I thought about the kitchen on Ferncliff Road on a Tuesday evening in March, and her voice on a recording saying the incompetency ruling was the cleanest path. I thought about Eleanor's grave on a rise in Virginia, behind a gate that now bore a construction notice put there by a company that believed it had purchased the land legally. I thought about 7 sentences on embossed stationery, about an intake form with my name in the resident field. I reached down and gently took her hands from my arm. I held them for a moment, both of them, the way you hold something you have decided to put down and understand you will not pick up again. Her hands were cold. I noticed that. I noticed it the way you notice a detail that your mind files away, not because it is important, but because it is the last time, and the last time always registers, whether you intend it to or not. "Maggie," I said, "fear explains things. It does not excuse them. There is a difference between those 2 words, and I think you have understood that difference for a very long time. You chose anyway. That is the part I cannot get past." I let go of her hands. I turned and walked toward the elevator. Behind me, I heard her say my name one more time, the particular way she had always said it when she wanted something, the inflection that had worked on me reliably for 22 years. I did not stop. The elevator doors opened. I stepped inside. They closed, and there was only the quiet, mechanical hum of the descent and the October light visible through the small window in the door getting smaller as the floors passed, and then the lobby and Frank. He was standing near the entrance with his hands in his coat pockets, exactly where he had said he would be. He fell into step beside me without a word, the way he had been falling into step beside me for 45 years, and we walked out through the courthouse doors and into the October afternoon, which was warm and clear and entirely indifferent to what had just concluded inside its walls. "Coffee," Frank said. "No," I said. "Drive." He did not ask where. He understood that I did not know yet, and that not knowing was the point. We drove through Charlotte for a while, through neighborhoods I had lived alongside for decades, without ever simply moving through them without a destination. And I watched the city pass, and felt something I had not felt in longer than I could accurately measure. I felt like a man with no obligations to the next hour. In November, I signed 4 documents on 4 separate days, each one a formal conclusion to a chapter I was finished with. The first established the Eleanor Hayes Harmon Foundation, funded with $6 million of my personal capital, dedicated to literacy programs and library access in underserved communities across North Carolina, because Eleanor had spent her working life surrounded by books and had believed without reservation that the right to read was not a privilege conferred by circumstance, but a foundational human entitlement. The second was an amended will. The third was a management transition agreement for Harmon Capital Partners, transferring operational authority to a leadership team that had spent years earning what Connor had spent 18 months attempting to take. The fourth was a deed transfer for the Ferncliff Roadhouse, which was more space than one person needed, and which Lena had already found a replacement for, a smaller place on the east side of Charlotte, with a yard deep enough for a real garden. Lena called the afternoon I signed the last one. "How does it feel?" she asked. I sat with that question for a moment. Outside the window, the November light was coming through the trees at the same long, flat angle it always had in the late fall, the same angle Eleanor had loved in Virginia, the one she had called with the particular conviction she brought to things she meant completely, the closest thing she knew to perfect. "Then it feels," I said, "like a Tuesday evening when all the work is done and you can finally stop." I did not win by watching them fall. I won by refusing to fall with them. And in the end, that was the only victory that ever mattered. I have told you this family story not because I am proud of every decision I made, but because I believe someone out there needs to hear it. Here is what I know now, standing on the other side of it. Trust is not given because someone shares your name. It is earned every day through choices made when no one is watching. I learned that lesson later than I should have. Do not wait as long as I did. If I could speak to a younger version of myself, I would say this: build carefully, document everything, and never confuse someone's proximity to your life with their loyalty to it. I also believe, and I say this as a man who has sat alone in the dark and asked God why the people closest to you can become the ones who hurt you most, that even in our deepest betrayals there is a path forward. Not back to what was, forward to what can still be. This Grandpa Stories is mine, every word of it. If this family story moved something in, you leave a comment below. Tell me where you are listening from. Share this with someone who needs to hear it. And if you want more Grandpa Stories like this, subscribe to this channel. There are more stories waiting. Thank you for staying until the end. It means more than you know. The stories ahead contain fictional elements crafted for reflection and life lessons. If that is not the content you are looking for, no hard feelings. Choose what serves you best.